Hello, this is Matt on the Moon Lambo channel. Got a few updates for you in this latest Moon Lambo hot jam, including something ridiculous occurring in the SEC versus Library case. SEC blatantly breaking the court's rules, and the judge saying, okay, that's fine, you can do that. Unbelievable. That's it. The SEC gets away with a lot more than I'd like them to get away with. Demanding things, and then even specifically, I'm thinking about the SEC versus Ripple case, demanding all sorts of extensions, and the judge effectively capitulating. And not that I'm unhappy with Judge Netburn and Torres on the whole. I think overall well, but still, it's amazing to me some of the stuff that these folks get away with. Also, I want to highlight the degree to which SEC Supreme Leader and Dictator Kim Jong-Gary doesn't mind harming you, the XRP holder, or any crypto holder. Is happy to do that, and is also happy to protect the banks. So rather than protecting investors, looks like he's out to protect the banks and the legacy financial system. And also, look at this headline from CoinDesk. This is amazing. The SEC violated the constitutional rights of at least one individual. Look at this headline from CoinDesk. U.S. Appeals Court orders SEC to bring enforcement actions to jury trials. Absolutely astonishing stuff. So it's not that this will surprise you, but it will highlight the degree to which these people at the SEC have been getting away with some horrendous things, and they are complete and utter assets. That's the message that I'd like to convey. And I'm going to do it because it's my channel, damn it, and I do what I want. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, in a recent video, I highlighted that in the SEC versus Library case, which is going to be highly consequential to what happens ultimately, at least to some degree consequential to what happens in the SEC versus Ripple case, because it'll be precedent-setting. Even if the precedent won't be binding, and it won't, it would still have just an impact, because that case will be a precedent. And it's good, the SEC is going to be filing all sorts of crap should they win. Well, recently, they filed when their document having to do with summary judgment for the SEC versus Library case, and they went 30 pages over what was allowed. So they were allowed initially, I think it was 25 pages. I could be mistaken on the number. I think that's right. But they filed like 55 pages, and the judge just allowed it. Take a look at this. Here's the update from attorney James K. Filan, member of the XRP community. Hashtag XRP community, hashtag SEC versus Ripple, hashtag library. In a text-only order, the judge in the SEC versus Library case has granted the SEC's motion to exceed the page limit and denied Library's motion to strike. The order is below. It's not clear yet how/if this will impact the trial schedule. And attorney Hogan, he responded to that and wrote, "This is pretty weak sauce. I thought this judge was Old Testament style." And the Library responded to this, and I'll censor it. You can read it on your screen if you really want to, but he wrote, "Complete BS. Not sure why we're having a trial when the SEC doesn't even have to follow the rules of the court." And I gotta admit, this is very disturbing, to blatantly break rules like this, and then the judge is like, okay, well, you can do that. No, that doesn't make any damn sense. And in fact, attorney Hogan, he had another comment here. He responded to Library, the official Twitter account, and wrote, "This ruling is disappointing. When you tell your kids they can take only one cookie each, and one of your children takes two, do you allow the other child to take a second, or do you tell the child that broke your rule to put the dang cookie back?" Excellent way of articulating the point and illustrating absurdity. Well, apparently everybody just gets a second cookie. That's what's happening here. So Library, they get to write more, they get to have extra pages, just the SEC did. Why? Because reasons. And it's a text-only order, so it's not like there's some sort of thorough explanation of why this is the case. But that's what the judge decided. Pretty ridiculous, I know. And then there was this. Here's a speech from SEC Supreme Leader and Dictator Kim Jong-Gary from 3 days ago. This is on May 17th, and I'm not going to go through much of this. I just found out this existed today, but he did talk about some crypto-related stuff, and attorney Deaton had something to say about this ultimately. But first, I want to share with you this tweet from XRP community member Stefan Huber, who highlighted a couple key portions. So I'll just make this full screen. And Stefan wrote the following: "Watch this. That's the only thing Gary cares about. his bank executive friends who whine about customers pulling their money out and investing in decentralized finance. It's not the investor's desire to be protected by Gary, it's the bank's desire to have Gary protecting them. And so just anybody out there listening, feel free to raise your hand if you feel like Gary Gensler's protecting you. Everybody feels super duper protected. No, I don't see any hands raised out there, and granted you were in a different geographic location on the planet right now. I recognize that, but still, I don't think there's any hands raised right now. So, what's he actually doing? Well, just listen to his words. Here's part of what he stated. This is part of his speech. He said, over the past year, several bank executives have shared their concerns with me about the sheer number of depositors who have moved money from their bank accounts into crypto-related exchanges and wallets. Folks, why is that something to be concerned? Like, people freely doing what they want, free and open markets. Why is that supposed to be a concern? Bad for banks because business goes away? Well, find a better way to compete. Maybe get into crypto. Maybe offer custody. Offer cryptocurrencies. Whatever. You can expand your business here. Quit crying about it because things are evolving and the legacy financial system, if it's going to exist, it needs to evolve with the times. But to just try and protect the legacy financial system so that they don't have to innovate in any sort of way, that seems like a terrible way to go about things. And then Gary also said the following. As I hear from bank executives about their customers shifting their savings to speculative crypto assets, I think of how Mr. Daly responded to a clear need to protect investors as technology and finance change. There you go. Things are changing, and he's calling it, what he's doing, protection. No. It's stopping innovation in its tracks. That's what you're doing. You're trying to destroy the entire cryptocurrency asset class in the United States. Because you just want the power, Gary Gensler. It's clear by your behaviors and also what you're saying here. Couldn't be more obvious, right? And so here's what Attorney John Deaton had to say about this. Because he shared that tweet from Stefan Huber, and he said, this really does sum up Gary Gensler's problem with crypto, and it is in his own words. I can envision him listening to the Jamie Dimons of the world, shaking his head in disgust and thinking, we have to stop people from taking money out of the bank. Exactly. That's exactly what this looks like. And he doesn't care. Your freedom be damned, United States citizen. You will listen to us at the SEC. Again, Supreme Leader and Dictator Kim Jong-Gary, everybody. And these people are absolutely awful. If I could just reiterate that. Again, here's the headline from CoinDesk, literally violating constitutional right here. The title again of this piece, U.S. Appeals Court orders SEC to bring enforcement action to jury trials. Now, this is completely outrageous. Let me share with you what happened here. Absolutely unacceptable and outrageous. A U.S. appeals court ruled the Securities and Exchange Commission violated a hedge fund manager's constitutional rights by having an in-house judge try a securities fraud case brought against the individual. The SEC alleged in 2013 that George Jarkessi Jr. and his firm, Patriot 28 LLC, violated federal securities law by misstating his two hedge funds' assets. The case was tried before an administrative law judge rather than before a civil court. Did you hear that part? That's a key part. The case was tried before an administrative law judge rather than before a civil court. These administrative law judges, or in-house judges, may have violated Jarkessi's Seventh Amendment constitutional rights to a jury trial, the Fifth Circuit Court of Appeals said in its ruling Wednesday. And here's a quote from the court. This is from the actual decision. So they did break it. There's no question about that. Here's the quote. In sum, we agree with petitioners that the SEC proceedings below were unconstitutional. The SEC's judgment should be vacated for at least two reasons. Number one, petitioners were deprived of their Seventh Amendment right to a civil jury. And number two, Congress unconstitutionally delegated legislative power to the SEC by failing to give the SEC an intelligible principle by which to exercise the delegated power. End quote. Anybody surprised by this? They think they're God over there. That's basically, they all do. Not literally all of them. There's people like Hester Peirce. I'm a fan of Hester Peirce to this point. There are others. I like Elad Roisman. He's left the SEC, unfortunately. But most of them, my gosh, it's just a complete asshattery out there. Completely ridiculous. And I wanted to add an additional comment here on a topic that I covered the other day in a separate video. Here's a tweet from Attorney Jeremy Hogan, and he's highlighting a document that's filed by Ripple. It was on the topic of requests for admission in the court. And here, the SEC won't admit things that are basic, obvious, true facts, and they're doing it just to make things more difficult, like a petulant child. And so Jeremy Hogan wrote the following. Here, remarkably, the SEC won't even concede that certain speeches were made and that the transcripts on their own website are accurate transcripts of the speeches. This failure by SEC counsel wastes time, money, and resources. It's on their own damn website, folks. These are petulant children. They don't care. Wasting the tax dollars paid by you and me out there. Or if you're not in the United States, then not you. But still, you get the cut of my jib. Well, attorney Deaton, he retweeted that, and he said the following. Gary Gensler is complaining about a lack of resources because he has his office pursuing regulation by enforcement in the crypto space. But Gensler's lawyers waste time by not agreeing a speech on its website is a speech on its website. Isn't that true? And so what he's referencing there in addition to that is the fact that Gary Gensler is requesting more taxpayer dollars, wants to hire a bunch more people, and get even more aggressive against the crypto asset class. That's what he wants to do. He wants to expand his burdensome approach, which, frankly, I think is outside the scope of what the SEC should be doing anyway. That's pretty damn clear. But he actually has the goal to ask for more money when he's just wasting resources on crap like this. Completely absurd. Really grinds my gears, folks. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write, so that would be a very, very, very bad idea. Until next time, to the Moon Lambo.